Welcome back to Courtroom Chronicles. Today's case is a roller coaster. We're diving into the story of John James Longley, a man standing before the court with not one, not two, but 6 prior felony convictions, and now facing yet another charge. The judge? She's not holding back. From questioning his honesty to nearly doubling his bond, this hearing spirals fast. But what pushes the judge to the edge? Stay tuned, because this courtroom just turned into a reality check no one saw coming.
About hiring, so it's the court for giving 4 weeks, I think. They did that pretty close.
You are, just to make sure that you understand fully, you are charged with the state jail felony of theft of property here in paragraph 1. And that would be a state jail felony normally, carrying with it up to 2 years in the state jail. But you have 3 prior felony convictions out of, there's another page. 4 listed here in the indictment, 2 on October 28th, 2009, out of burglaries of habitations out of Hardin County District Court. Thereafter, those were final. It is alleged in paragraph 3 of page 2 that you committed the felony of burglary of a habitation and were convicted in district court in 2014 in clause number 20272. After that became final, you committed the felony of burglary of a habitation and were convicted another burglary and convicted of that one in the 260th District Court of Orange County, Texas. So it's my understanding the way this is pleaded, if all of this was true, you were looking at a state jail felony, but it is punished as though it were a second degree felony. So you were looking at no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. You understand what you're looking at?
Yes, sir.
All right, the court has looked at this probable cause. What is the bond in this case?
I believe it's 10,000.
$10,000. Looking at a public safety report that is dated February 11th of this year. Were you appointed on this?
Yes, sir. This is the first time,
So your bond is $10,000? Is that what it is?
Yes, sir.
Okay. The court is going to modify.
And here's where the tension really spikes. The judge just modified Longley's bond, citing his horrific criminal history. That's a strong statement from the bench. She orders home confinement with GPS monitoring, basically digital house arrest. When a judge explicitly says, "I don't trust you," that's not courtroom theatrics. That's a clear message. Your record speaks louder than your words.
The bond in this case is the court does not trust you with this prolific criminal history. I want you to be on home confinement. You have to have a GPS device on you by the end of this day. And I want to, so I'll know where you are at all times. I don't trust you in this, looking at all of this. This is terrible.
Judge, this.
No, I'm speaking.
Yes, sir.
You have so many convictions here. And these just aren't burglaries of anything. These are burglaries of people's homes over and over and over and over again. And the probable cause affidavit here alleges you took somebody's credit card and misused it.
It was given to me.
You know what? This is not a debate. It's what the probable cause, and you can, in the grand jury indicted you based upon these facts. You're presumed innocent, but there is probable cause to believe you committed this crime based upon these facts. Okay. Here's my favorite part. In the probable cause, you told the victim here, by the way, it was $8,000, over $8,000 in charges. Boy, borrowed it for $8,000. I've never heard of such a thing. Who would trust you in for a dime? I wouldn't let you, I wouldn't give you a quarter of mine to hold. I wouldn't trust it. And what did you say here? You would pay the funds back according to this probable cause, but you never did.
Yes, sir.
Which is what the probable cause states under oath.
This is one of those, did that really just happen? Moments. The judge literally says, I should have put you under oath because you can't even be straightforward with me right now. That's as close as it gets to calling someone a liar in open court. Legally, of course. And when she calls him a certified thief, that's not just name-calling. It's a reflection of his multiple prior burglary convictions, all admissible to judge his credibility if this goes to trial. Brutal, but lawful.
That is, when did you pay these people?
I started paying them on.
No. When did you pay it back? You said you paid it back. When did you pay it back?
I was making payments with them.
You haven't paid it back, have you? Completely?
Not the full amount, no.
See,
No,
you're trying to take my wallet right in front of me.
No,
Yes, I said, did you pay it? You said I paid it back. You haven't paid it. Do I have to cross-examine you to get the truth out? This is terrible.
I was making payments with them.
Yeah. You are certified thief. All these convictions. And then you come up in here, I should have put you under oath because you can't even be straightforward with me right now. You're hedging in your statements. I got to correct you to get the right information. Yeah, good luck. Because all of this is admissible, which the jury can consider in evaluating your credibility at a trial. It doesn't take 6 convictions of burglaries to convince anybody that you are a dangerous person and not an honest person. And here you are, charged with that. Again, probable cause to believe that happened. All right. The end of the day, you're at home confinement. You have a GPS device. You don't leave home except for the following things: for a medical need, to get food, to go to and from work. And those are the most direct routes possible. You have to have that by the end of the day. If I don't learn that you have it on you by the end of the day, a warrant will be issued for your arrest and you will have no bond. You will sit that out until we get around to getting this case done. So I'm considering raising your bond anyway. Just for the way you handled yourself and not being forthright. Your bond ought to be 6 figures, what it ought to be. Oh, you think your criminal history and a new charge aren't worthy of that? Okay. There's a way to fix all of this, but you should have fixed it 6 convictions ago. All right. Back to you, John.
And just like that, the judge cuts Longley's request in half, from 4 weeks to 2. No sympathy, no trust, no extensions. This case highlights exactly why repeat offenders face such steep uphill battles. Every prior mistake echoes louder in court. The takeaway? In the justice system, your history can be your harshest prosecutor. If you found this case as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom moments and expert legal breakdowns. Until next time, this is Courtroom Chronicles, signing off. Today's courtroom is a storm of chaos and consequences. Meet Sadie Ivan Murphy, a woman once offered a second chance through probation and treatment. But things took a dark turn behind bars. Violent incidents, self-harm, and a judge caught between compassion and control. As tensions rise, one question hangs in the air. Can rehabilitation save someone spiraling out of control? Or has the line already been crossed? Stay tuned, because this one ends with a hard reality check from the bench.
In the jail, violent ones. So we have pulled that offer.
What's the deal on that? We have Dr. Rapon's report. She ought to be okay.
Yeah, we had safety on MQRP and 10 years deferred, but it's come to light that apparently she's been having some issues in jail. I didn't know.
It's on my watch. What is it? What issues are we talking about?
I just found out today. I didn't know about it.
Your Honor, based on the incident reports that we're able to see through Odyssey,
Yeah.
I've printed some. They're very difficult to transfer into other than snipping and clipping. But we have reports, a stack of them dating back to where
So when?
her first incarceration in last July of 2024, since she's been in custody.
Well, I want to know what happened since September 18th of 24. That's when Dr. Rapon evaluated the defendant, and we.
I printed one from July 21st of 24, which was an information report. In
From when? What's that?
July 21st of 24, we go to December 21st of 24, December 27th of 24, as recent as March 9th of 2025, March 2nd, 2025, and February, I believe this was February the 20th of 2025.
Okay.
Incidents that include her attempting to take her own life, as recent as, I believe, yesterday. She had asked to speak to a mental health provider.
This is a deeply alarming detail. Murphy reportedly tells staff she might harm someone and is found with a rope twisted around her hands. In any courtroom, this signals two major concerns. One, her mental health is in serious crisis, and two, she poses a threat to others. Judges must walk a tightrope here, balancing safety with compassion. But when violence becomes repetitive, sympathy starts to fade. It's tragic, because what started as a plea for treatment is turning into a case about danger and control.
37 days.
237 days, Your Honor, and Ms. Murphy is exhibiting continued aggression and violence and lack of respect for authority. And
Okay.
I do understand that Ms. Murphy has a need for substance abuse treatment. That was the reason for the initial request for SafeP, but the behavior she exhibits in custody right now at a SafeP unit would be totally unacceptable. It's unacceptable in our facility.
Of course.
And the danger that we're putting other
All right. Okay.
clients in.
Well, I looked at Dr. Rapon's report, which I trust, and he determines that she is competent. So the choices people make are the choices they have to live by. And if you make bad choices, then you're going to be punished. If you make good choices, you're rewarded. It's the way it works. It's that simple. And that works in this court as well as in the free world. And we can't have assaultive behavior anywhere, much less in the jail where we've got a lot of people that the authorities have to maintain control over. The important thing that you must remember is that you're looking at a third degree felony and it's on my watch and it's my decision on a motion to revoke probation. At the end of the day, it's going to be mine. And then you got this new case of another third degree felony, and both of these are assaults. And this new case was filed. Alleges August 13th and of 24. So I had placed you on probation. 2 months later, you're assaulting another public servant. And obviously that is not something we're going to tolerate. Shame on you the first time. Shame on me the second time if I don't do the right thing on my watch. We'll just have a motion to revoke probation hearing. We'll set this first in just a couple of weeks.
Okay.
I mean, it's going to be the allegations. Well, we've got 6 of them, right? No, 2. Yeah, 6. And they are administrative. And then 1 is the new case here. And the court will be the arbiter on this one. And I need this back in the file, Dr. Grapon's report. All right, y'all be ready.
Thank you,
and be prepared. So I intend to resolve this in 2 weeks in one direction or another. Okay. Thanks. Yes. All right. Next is Marvin. What's this?
We reached a deal in lieu of, we have a new deal now.
A what?
We got a new deal.
You said a new deal.
New deal.
That's 2 news.
Two new deals.
That's too much news.
That's too much, huh? Yeah, we were able to work it out this morning.
A few minutes ago, there were no deal based upon her conduct. Now what?
What happened was the old deal was deferred and safe P. Now the new deal that we reached is 5 years TDCJ, which is going to be pen time. That's the new deal.
On what? Both cases?
In both cases to run concurrent. And that way we'll dispose of both cases today. And like I understand, the state is no longer going to do the probation deal. So we reached an agreement for the pen time deal.
Is that what you want?
Yes, sir. And that'll finalize it.
Oh, let's do this in numerical sequence. Okay. The first one is cause number 24-CR1187, the motion to revoke probation, a first amended motion to revoke probation. And this is the state of Texas versus Sadie Yvonne Murphy. That is you. You have to speak out so she can hear. Okay. And Mr. Adams is representing you and the state's attorney is here. There's a first amended motion to revoke unadjudicated probation. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, sir.
And raise your right hand, ma'am. Do you solemnly swear or affirm any statements you make during these hearings will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hands, perfect. In summary, this first amended motion to revoke unadjudicated probation states that on June 10th, 2024, in this court, that you were placed on 10 years deferred or unadjudicated probation for the third degree felony of assault of a public servant. Do you understand what you're charged with here?
Yes.
Allegation 6
Yes, Your Honor.
alleges what's in this new indictment, 24-CR1984, and we will use this as the basis on this motion to revoke probation in this case. Number 6 states that you violated your deferred or probation order by committing the offense of assault of a public servant on or about August 13th, 2024 in Jefferson County, Texas. Do you understand fully what you're charged with in this allegation?
Yes, sir.
Is this allegation true or untrue?
True.
Are you pleading true voluntarily, knowingly, intelligently, and after discussions with your attorney?
Yes, sir.
You understand that a knowing and voluntary plea of true to one or more violations of probation, that would be enough to grant the motion to revoke probation. Your probation can be revoked, and you could be sentenced to no less than 2 nor more than 10 years confinement in prison since you're on probation for a third-degree felony. No.
This is a deeply alarming detail. Murphy reportedly tells staff she might harm someone and is found with a rope twisted around her hands. In any courtroom, this signals 2 major concerns. 1, her mental health is in serious crisis, and 2, she poses a threat to others. Judges must walk a tightrope here, balancing safety with compassion. But when violence becomes repetitive, sympathy starts to fade. It's tragic, because what started as a plea for treatment is turning into a case about danger and control.
Or 1984. Is all of that true?
Yes, sir.
These sentences would run concurrently, correct? If I follow this, you have no right of appeal. You understand?
Yes, sir.
Did you sign that document? Understand it? Discuss it with your attorney? Is everything true and correct?
Yes.
States Exhibit 1 tendered into evidence?
No objection.
Without objection admitted? In summary, this states that if I follow this agreement, you will have no right of appeal on this motion to revoke probation disposition.
Yes, sir.
Okay, then it is made a part of the record. I'm going to follow this agreement and find there is sufficient evidence supporting this motion, first admitted motion to revoke unadjudicated probation, to grant it by a preponderance of the evidence or greater. Allegation 6 is proven true as the defendant has knowingly and voluntarily pleaded true to that allegation of committing the new offense of assault on a public servant, which was indicted and represented in the new cause number 24 CR 1984 in this court. Thus, your deferred or unadjudicated probation is hereby revoked, as I find you have committed this violation, proving by a preponderance of the evidence or greater. Earlier in this case, you had pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea at that time through States Exhibit 1 admitted in the hearing to find you guilty beyond a reasonable doubt. Your deferred or unadjudicated probation is hereby revoked. I now find you guilty beyond a reasonable doubt of this offense in 1187, again, a third-degree felony of assault on a public servant. And finding you guilty beyond a reasonable doubt, I follow this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. 24 CR 1984 is now called. Does the defendant waive a formal reading of this? And we proceed in summary here.
Yes.
In summary, this indictment alleges that was handed up on September of last year, that on or about August 13th, 2024 in Jefferson County, Texas, you committed the third-degree felony of assault on a public servant by assaulting someone who was a correctional facility employee at the jail in Jefferson County, Texas. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement's been reached in this case as well. You would be pleading guilty, found guilty, sentenced to 5 years in prison to run concurrently with the preceding case that we revoked you on. Is that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand that?
Yes.
How do you plead to this, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will, and because you are indeed guilty of what this alleges. I show you what's marked as States Exhibit 1 in this case. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents true and correct?
Yes.
States Exhibit 1 is tendered into evidence
No objection.
without objection admitted. And this states as well that you were mentally competent to enter your guilty plea. And we all know from Dr. Capon's report that you've been analyzed and found competent, and there's no indication the defendant is incompetent,
No.
correct? And you are totally satisfied with the representation provided by your attorney. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You understand what you're charged with. The indictment's been read to you. You've read it. You were guilty of that crime and any lesser included offenses. So help you God. State's Exhibit 1. That is part of the record for all purposes without objection. Pre-sentence report is when?
Yes, sir.
I'm going to follow this agreement and find, if nothing further, that you, ma'am, are pleading guilty here voluntarily, mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I'm doing that. I'm going to find you guilty beyond a reasonable doubt, as agreed upon by all the parties and as you have elicited in your plea of guilty. And I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. These two sentences shall run concurrently. Do you understand what has happened today?
Yes, sir.
Looks like what we have is an anger management problem that is something we all deal with. We all wrestle with. It's not like you're odd, you're normal, and we all get upset and lose our composure from time to time. It's normal. But you have to be able to think ahead on this and go, look, I'm going to get upset, but I've got to rationalize this early and have a plan. When I catch myself doing this, I've got to do something to talk to myself so that I am alert that, hey, this will have consequences and I could be punished severely. Is it worth it for a silly hissy fit that doesn't really get you anywhere? And you know, we all struggle sometimes with losing composure, but you have to grab a hold of yourself and think, how much do I have to lose and how much do I have to gain? Generally, is not anything to gain and everything to lose. And that's the way it is for everyone. Kind of think about that. Plan ahead, because it'll happen again. And you just don't want to go to prison over something that's just losing your composure over. And I know it's frustrating. You go, this is just, I don't like this. This isn't fair. But we all have to deal with it. And sometimes you have to shrug it off and move on.
This is the moment everything changes. By pleading true to the violation, Murphy effectively admits guilt. No trial, no excuses. That's a legal surrender. It's rare to see a defendant plead true when the consequences are this steep. But it shows she either accepts her fate or realizes she's out of options. Under Texas law, that one plea allows the judge to revoke her probation and impose up to 10 years. The fact that the state agreed to 5 concurrent years means she's getting some mercy. But make no mistake, the judge is sending a message. Welcome back to Courtroom Chronicles. And today, we've got a stacked docket. 3 defendants, 3 drastically different stories, and one judge trying to keep it all under control. First, we've got Mr. Huff, facing probation violations and confusion over new charges. Then, a shocking firearm case that raises serious legal stakes. And just when you think it's over, a final twist. A defendant accused of using a coffee mug as a deadly weapon. Yeah, you heard that right. Grab your seat, because this courtroom's about to heat up fast.
Charged with state jail felonies of criminal mischief, it looks like. You were placed on probation for up to 5 years on December 2nd, and he's already pleaded true.
Yes, we were here once before, Judge, and he was reinstated because there was a significant amount of restitution involved in the cases. And now we're back here again.
They locked me up for trespassing one. That's why I'm in jail. I went here for a motion to revoke. They locked me up for trespassing.
Do y'all need to amend this motion?
I don't know, Judge. I have not looked at it.
It does need to be amended, Judge. There has not been a first.
Okay, so there's a substantive offense that's come along, allegedly.
There's subsequent allegations. I'm not sure if it's a substantive offense, but.
Well, we put him on probation
In December of 2024.
I'm talking about this allegation true in June. What did I find then? What was my resolvement on this?
You reinstated his probation.
Okay, that's done. What happened subsequent to that?
I don't know. I don't have a new motion to revoke probation file.
He failed to report, Your Honor. He hasn't reported since continued on probation.
Okay.
It's my understanding.
yeah, I have
that
my-
it's absconded.
You're interrupting.
Yes, sir.
Yeah.
But I'm a lawyer too.
Is that just a smart aleck comment
No, that's
or
not.
just you,
No, sir.
you're going to step over me
No, sir.
all the time, the whole time?
No, sir.
Shh.
Yes,
You're
sir.
going to get a chance to speak, but the lady has to put down everything as the court reporter. And when two people are speaking, she can't do it. That means somebody gets in trouble. All right. Okay. So the,
I'm sorry, Liza.
motion, it sounds like another motion to revoke probation needs to be filed.
And it seems like I have some motions that I need to file as well, Judge.
All right, then,
Seems like.
can y'all do that in 2 weeks,
Yes, sir.
everybody? So this man knows what direction he's going to be heading in?
Yes, sir.
The tension here is thick. You can feel the judge's frustration. He's giving Huff another 2 weeks, one final window to figure out his legal direction. But look closely. The judge's tone says it all. He's out of patience. This moment captures what happens in court when second chances start to run out. The courtroom isn't just about punishment, it's about accountability. And Huff's silence, his short replies, they speak volumes. Do you think he'll make it back and turn things around? Or is this delay just the calm before another downfall?
Felony of deadly conduct. And can we proceed in summary?
Yes, Judge.
In summary, sir, this indictment alleges that on or about May 5th, 2025, in Jefferson County, Texas, you committed the third-degree felony of deadly conduct by discharging a firearm in the direction of a habitation. Do you understand what you were charged with here, sir?
Yes, sir.
This is a third-degree felony if convicted, which means you face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range that's applicable?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. You do well, and it gets closed out early in a third of the time. Another case, 25 CR 1289 will be dismissed. What is that?
It's a
misdemeanor.
on the.
Oh, okay.
Weapon, Judge.
And then you've got this Glock 19 that was involved here. This is going to be forfeited as part of this agreement to the state. Is that your understanding of the agreement?
Yes,
And it
sir.
was a $500 fine also on this deferred or unadjudicated probation. If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead in this case? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Yes.
Yes, sir.
I'll show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it, discuss it with your attorney or the contents all true and correct. State's Exhibit 1 tendered into evidence
objection.
without objection, it's admitted. Among other things, State's Exhibit 1 states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You voted. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. John West is on the YouTube and his tie is showing. This is, do you understand all of this to be true and correct, sir? In State's Exhibit 1. State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived?
Yes, Judge.
All right. If nothing further, I'm going to follow this agreement. McCarrick, anything you want to add? All right. If nothing further, I'm going to find you are pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to place you on deferred or unadjudicated probation.
This part right here is fascinating. The judge gives the defendant a deferred probation instead of prison time. A massive lifeline. But let's not miss the fine print. He's also losing his Glock 19 permanently and paying $500 in fines. More importantly, if he fails probation, he could get 10 years behind bars instantly. The judge's warning is crystal clear. Move on with your life and do better. It's rare to see this kind of leniency paired with such a firm tone. What do you think? Fair deal or risky gamble for the state?
Anything else we missed on? You're going to see the probation officer here in just a moment. He will go over all these terms and conditions of probation. Do well. It's in your best interest. You become a better person. And this gets shortened. You don't get a conviction. If you fail, your case could be revoked. You could be found guilty then and sentenced up to 10 years in prison. And then that comes with all kinds of problems. This alleges that you discharged a firearm at or in the direction of a habitation. The use of a firearm in the commission of an offense, if convicted, will affect your parole poorly. It has a negative effect on it. You understand? So move on with your life and do better. Okay. All right. Please see that nice man. We'll see him. Thank you. Do well. Yes, sir. Uh, 24 CR 2059 is called. You were Quincy Taylor?
Yes, sir.
Mr. Taylor, and you are charged here with an indictment alleging that you committed the second-degree felony of aggravated assault with a deadly weapon. A second-degree felony, if convicted, carries with it no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're facing? Mm-hmm. Well, it doesn't end there, because the indictment also includes 2 prior convictions. One in June of 2007 for obstruction or retaliation, a third-degree felony. And this states you were convicted out of the 361st District Court of Brazos County, Texas. After that conviction was final, paragraph 3 in this indictment states you committed the felony of aggravated assault with a deadly weapon, a second-degree felony, and you were finally convicted of that crime in 2017 out of the 85th District Court of Brazos County, Texas. And now, after those 2 are completed, this alleges you committed this offense here in March of last year, a second-degree felony. So, if all of this was true, found true, those prior convictions were true as they are alleged, and then if you're convicted of this, then this is what we call habitual felony status, which means you are looking at, if convicted, no less than 25 years in prison, up to 99 years confinement in prison, or life imprisonment, and and a fine up to $10,000 could be assessed. It doesn't end there. The allegation here in this indictment is that you committed this aggravated assault and with a deadly weapon, and the deadly weapon is alleged to have been a mug, I guess a coffee cup kind of thing. Cool. And that in the manner of its use and intended use was capable of causing serious bodily injury or death, as you intentionally, knowingly, or recklessly, it is alleged, caused bodily injury to the complainant by striking him in the head with the mug. And the way it is alleged, if this was found true, then whatever sentence you receive, you cannot be released from prison for parole until you serve at least 50% of the time. So if you were sentenced to 30, you'd have to serve 15 before you were released. So these are all serious allegations, and you have to be careful as you work your way through this one. Do you understand?
3 defendants, 3 wildly different outcomes. One might get another shot at probation, another walks free on a deferred deal, and the last faces the fight of his life, possibly decades behind bars for a moment of violence. What we just saw shows how unpredictable courtroom justice can be. It's a balance between mercy and the weight of the law. So what do you think? Were these rulings fair or too forgiving? Drop your thoughts below. And if you found this courtroom breakdown as intense as we did, make sure to hit that like button, share the video, and subscribe for more real courtroom drama. Every verdict, Every twist, every truth revealed right here. Welcome back to Courtroom Chronicles, and buckle up, because today's case is a wild one. We're diving into the chaotic hearing of Marcus Miles, a man with a long rap sheet and an even longer attitude problem. From failed drug tests to outbursts in court, this one spirals fast, and Judge Stevens isn't playing around. By the end, things explode when a simple interruption leads to a massive $50,000 bond. Stay tuned. This hearing is pure courtroom tension.
Today?
Your Honor, we're asking for a 3-week reset at least in order to get this case reindicted with the correct officer's name.
Okay. All right. Any objection at all? Did you say 3 weeks?
Yes, at least.
Okay. All right. Done. Just want to make sure, get a resetting and then have a reset seat over there before he leaves.
I don't think he's gonna be able to get a reset because it hasn't been indicted yet.
What's the reset to get, come here?
Okay, I'm just making sure,
We
Judge.
can reset this case and then when
Okay.
a new case comes, we'll just.
So now I'm just making sure, because I know that it's gonna be a new call, so I just want to make sure we're all in the same boat. So
They'll move it with them.
Mhm.
I trust them. Okay,
Me too.
they're gonna get you to reset so the next day to be here.
And then just have a seat right over there before you leave. I want to test you to make sure all is well.
No, no, right here. Yeah, you're
Get
good.
a resetting from that lady.
And then you're gonna need to sit over here. Right.
Right there.
Say that you.
And sir, this is from a fight. This right here, you see this? I got in a fight.
What does that have to do with what you're charged with?
I was trying to tell you.
Oh, okay. Wait, I got Sagar Patel is reset, right?
Correct.
Sagar?
Yes, sir.
That's right, Brent. Huh? Patel.
Well, my understanding is that's the first.
Well, I mean, it says reset. He doesn't need to be here, so you just have a seat in the box. Thanks. Michael Pete? Michael Pete? Three, take three.
You trying to dilute it?
Sit down. Sit down.
Now what?
He's asking him, could I get a He's being uncooperative, sir, man, or,
You don't have,
And here's where Marcus starts unraveling, interrupting, questioning orders, and testing the court's patience, literally. The judge orders a drug test, but Marcus argues and refuses. That's a major red flag. Refusing a court-ordered test is automatic grounds for bond revocation. The tension here isn't just about drugs, it's about defiance. What do you think? Should judges show patience in cases like this? Or is tough enforcement the only way to keep order?
going to be revoked for refusing to do that. Well, no matter what the result is, your bond is going to be revoked for refusing a court order. Do you understand? Now, we're going to wait all day if we have to, but if it gets to the dark, it's going to get revoked.
I'll get that, man.
Go do it. Go give them, a specimen.
There's another issue. You
Yeah.
asked
No, I do.
the gentleman back here just to put water in the test. I guess he wasn't able to actually urinate it.
I didn't tell you.
So he's trying to falsificate.
And that man, look, that man trying to see, look, sir, I told him to give me some water. He's sitting up there getting mad at me because I can't pee in the cup. He getting mad at me because I can't pee. That's what I'm saying. He getting mad at me because I can't pee.
He said he's gonna give you another chance.
All right, that's all.
Go on in there.
And you know, I've been coming up there. I ain't been running for nobody.
Not a debate. It's an order for you to give the specimen, sir. Thank you.
Yeah, just give him one more.
Now, you're going back here.
Who is your lawyer?
Brent.
Is he Brent? Yeah, okay.
And-
All right, and Marcus Miles, 24 CR, don't interrupt. You come right out and you're rude. You've been doing all the talking. That's all I hear. Just you back there for the last 30, 45 minutes doing all the talking, but you don't act. You're not acting in a responsible way. In 24 CR 1680, you were indicted by the grand jury for evading arrest or detention. And that is a state jail felony. And you have 3 prior convictions in 09 and 14 and 2021 in felony courts as well as county courts at law for evading arrest and detention. I mean, you would think after the first one, you'd understand what the rules are and how.
This is where the emotional meltdown begins. The judge's patience is clearly thinning. Marcus interrupts again and again, trying to explain himself mid-sentence. Judges value respect and silence in court, because every interruption undermines authority. It's not about ego, it's about control and procedure. And when Marcus casually calls another judge by her first name, that's the breaking point. In a courtroom, that's like throwing gasoline on a fire.
You to provide a urine test, which you have failed to do. His bond is what?
$6,500.
Okay. Your bond is increased to $15,000. Plus, you must have a drug patch as a condition of bond if you post the bond. Plus, you have to have a GPS device so I know where you are at all times. You want me to add some more? Every time you make a crass remark, it's another reason for me to lodge another condition of bond because you're just asking for it. You're giving me reasons why we need to be protected, the community, from your ridiculousness. Don't you think 1, 2, 3, 4, 5 convictions, felony convictions is enough and a sixth one on the way here with this one? It's time you started following the rules, Mr. Miles, like we all have to. Anyway, that's, I want a GPS device. You're going to be on home confinement. You can leave home if you do all of this, if you're able to get all of these conditions done. You have to stay home, but you can go to and from your lawyer, to and from food, to and from medical care, and to and from church. But you have to go in the most direct route possible, and you have to work with the company that's working with the GPS so that they know what those routes are. And then what are we going to do next? What's the next event? Trial?
Yeah, well, state, they have to re-indict this one.
That's correct, Judge. This is the one where the indictment was wrong.
Okay, well, I'm just going to put it on trial and we'll set it for trial. Let's move forward for that. And if it gets disposed of otherwise, then great. If not, let's fast track this. Okay, those are the conditions. And again, here, the standard bond conditions, sir, as you know, and this is why you're in the problem, is that everyone on bond is subject to being tested for drugs and alcohol at any time as directed by the court. That's standard bond condition number 2 of the criminal courts. Both of us, Judge West and I, have both signed these orders since 2022. Everybody knows what they are. You fail to provide these specimens as ordered, then that is why your bond gets revoked. All right, anything else? That is all. We're taking into custody. Thank you. Okay, let's now, Brent, let's get together on that plea agreement y'all got on Mr. Gothe, so we can move on to our next part of our life. We have you back here, Mr. Miles, in cause number 24 CR 1680. As you know, I had ordered you to provide a urine specimen, which you failed to do. And the bond, your bond, because it is based upon requirements, including, you know what? And if there was a felony for interrupting, you'd be guilty of that too. You can't help yourself. You got to be in control. You can't follow the rules of just common decency. So, one of the conditions of bond is you must provide specimens if ordered, and the court ordered you to do that. You failed. Your bond was increased to $15,000. Plus, I've ordered you a drug patch because of your criminal history with illegal possessions of drugs of drugs, a GPS and house arrest. I wanted to make sure you understood that house arrest is you can leave for those necessities. And I think I touched base with them. All medical necessities is a necessity. You need to have medical treatment. You can leave your house to and from the most direct route, food, to your attorney's office. This is all in the most direct route, and also a church. Those are all important if you need those. And again, you must, if you do get a GPS device, the people with the GPS need to know exactly where when you're going to go. You have to alert them ahead of time, and you have to tell them exactly where and in what route you're going to be taking. Do you understand that, sir?
Yes, sir.
One other thing. Apparently, the court next door is trying to select a jury, which apparently you and the other guys in there have interrupted. She came in to talk to y'all about it. Yeah, you're apologizing now, but you interrupted those court proceedings. Plus, you referred to her in a derogatory fashion.
I didn't know her name.
No, you said you referred to her as Raquel.
Sir, I didn't.
You can't help yourself but interrupt, can you? Let me speak, and you'll get a chance to be heard, sir. You don't. You have to speak to people with respect. Live honestly, harm no one, give each person respect. Those are the basic principles all of us for living together on this planet should respect and honor and practice. You, however, with your rich criminal history, have refused to follow the rules, and now you're showing disrespect to an elected official, a public servant. I know what you did. I know what you did. That $15,000, it's $50,000. It's $50,000. You have to show respect. You can't interrupt proceedings in this courthouse. We're trying to take care of a problem, the 22nd largest county with the 16th highest crime rate. We have, which includes you in the crime rate. We're doing our best to run as fast as we can. We don't need people who act like you, disrespectful, to continue to interfere with the proceedings. Do you understand everything I've said? I've spoken in English. Anything you want to say?
Yes, sir.
Go ahead.
About that, I was having a word with one of the little fellows, and I was trying to ask him what was going on, what like and she kind of like was walking by. And I was like, oh, she was like, can y'all keep it down in there? And I'm like,
you were interrupting the proceedings.
No, I didn't know that, boss.
We have courts on both sides. You have a rich history of.
My born has.
You know what? Let me just get this point out. You were convicted in this court. You have been convicted in the 252nd District Court next door. You know what these courts were, you know how close they are to the holding cells, and you know you can interfere with them. Don't act like you're amazed and I can't believe it's not butter. You know when you're acting loud and boisterous, you're going to interfere, and they're trying to pick a jury over there. And nonetheless, we're in business every day. But to refer to her in a derogatory fashion by calling her by her first name and you said some other things, but I'm just referring to that. She has earned respect. We've all earned respect, and we're going to respect you. But sir, you're not handling your problems responsibly. And your bond for interfering with the court proceedings next door goes up to $50,000. I can move it up some more if you want to keep violating conditions of bond or acting rudely, but let's just stop with this and learn our lesson and move forward. All right? Anything else?
Yes.
You've got a problem with this case. You need to deal with Mr. Turk in a responsible way. Don't be rude to him.
Yes, sir,
But you're in a big mess here.
my bond has just been revoked, sir, and you gotta look at how kind of like was lashing out in the cell. back
That's no
there.
excuse
Nah,
to interfere with the court proceedings.
Sir,
You can feel disappointed all day long, but you don't interfere with the court proceedings. Do you
I
understand?
apologize about that.
Well, you can't undo them. You can't do it
But I
when
didn't know
he
that-
has
I
to.
didn't know that was her. I didn't know that was her. I didn't-
You know where the courts are. You've been in both courts.
No.
Sir, you got a conviction in next door and you got a conviction here. Don't tell me that this is foreign to you. You know how this works.
Sir,
You're in holding cells. You've been in holding cells here in the past. We're just a few feet, both courts. You know what it is like. You were taken in and out of the holding cell, which is just a few feet from the courts. You know you can interfere with the proceedings by speaking rudely and loudly, and you did it.
I tried to apologize.
We'll try to. You need to act more responsibly and less rudely and show respect to people, everybody.
Just to tell you that I didn't even cuss. I didn't tell her nothing.
You interfered with their.
And that's where the gavel drops on Marcus Miles. A $50,000 bond, GPS tracking, drug patch, and house arrest. All because he couldn't stop talking over the judge. This case is a masterclass in how courtroom respect, or the lack of it, can completely reshape a defendant's future. So, what do you think? Was the judge too harsh, or was it fair given his history and behavior? Let us know in the comments. And if you found this breakdown as wild as we did, hit that like button, share this video, and don't forget to subscribe for more jaw-dropping courtroom moments, only on Courtroom Chronicles.